Okay then, I'm going to move on now to independent medical assessment. Can you direct an employee to attend an independent medical assessment? Now for anyone that doesn't know, an independent medical assessment is basically sending your employee off to an independent doctor, so not their own GP or a doctor that they've consulted with previously. There's usually, if you go onto Google, a whole heap of sort of medico-legal doctors that do these specialised reports, and often you have to wait a few weeks to get in with them. They charge a lot of money, so it's not something you want to do lightly. I would suggest trying to get consent to talk to the employee's own doctor first, potentially. But if you do need to go down this route, where maybe you've got an employee that's taking excessive sick leave, they might have used all of their paid sick leave, and they're then into unpaid sick leave, and it looks like they're just going to keep taking it, or you've got a situation where you're really worried about health and safety issues in the workplace with them or with other employees or clients, this may be something that you have to consider. So when can you actually direct them to go to a doctor like this? Basically, the cases in this area show that it has to be a lawful and reasonable direction, and there has to be a genuine need for it. So what that means is you can't just send someone off because you feel like finding out what their medical situation is. There must be something happening in the workplace that makes you think, I need to find out more information about this, and something in relation to health and safety or the inherent requirements of their role. So that's what it sort of boils down to. I've got two examples here of case law. The first one, Burns and Sacred Heart Mission, is about an employee that worked in crisis accommodation. She unfortunately was working when there was quite a serious incident that happened with a client trying to commit suicide. As a result of this, she started making some comments to colleagues that were worrying people. The employer became concerned that if another crisis situation like this arose, she wouldn't be able to react appropriately, and there may be a risk to her own health and safety, her colleagues, or the client's health and safety. So they suspended her on full pay, which is something which can be appropriate to do in these situations. If you're very concerned about health and safety, you should suspend on full pay. And they asked her to go off to an independent medical examination. She said, no, I'm not going to do that, and brought along a medical certificate saying she was fine and fit to work. So she was directed in a letter to go off to this independent medical examination, and she didn't turn up for it. She then didn't turn up for a meeting with the employer to explain why she hadn't gone. In this situation, the employer was actually very proactive and ended up directing her a couple of times to go off to see the independent doctor, and she didn't do so. She got legal advice and tried to ask them to withdraw the direction. Ultimately, they terminated her, and she brought a claim against them saying that she had been terminated unlawfully. So in this particular case, the judge went through what were the reasons that she was directed to go off to the doctor, and were they lawful and reasonable, and was there a genuine need? And ultimately it was found in this case it was completely lawful and reasonable because of those health and safety concerns. There's no problem at all in suspending someone on full pay and sending them off to do that. So I think that's a really clear example. So the next case is the Transport Workers Union and Cement Australia. This is the opposite extreme of the spectrum, where the employer tried to direct a whole segment of the workforce to go off and get a risk review program done. And this was due to particular concerns in this industry with musculoskeletal injuries happening in the workplace. So what they would do is they'd send these people off and they'd get all sorts of assessments done, blood pressure, taking measurements and weighing them, and then they would refer them to appropriate programs depending on whether they were high, medium or low risk of injury. And the union stepped in and said, no, we don't think you can do this. It's not lawful and reasonable, there's no genuine need for it. And all sorts of evidence was gone through, technical evidence as to would this help or would this not help, and what about all these injuries, and we're just trying to get them down and do the right thing. Ultimately, the Fair Work Commission in this particular case said it's not lawful or reasonable to send a whole segment of your workforce off. This is not about health and safety, a particular issue, and it's not about inherent requirements of the role. So you can't do this. You can provide voluntary options, membership for a gym if you want to, if you're trying to keep people's weight at the right level. This was truck drivers in this particular case. You could have quitting smoking programs, all these sorts of things, but they had to be voluntary. You couldn't force people to do it, and you certainly couldn't discipline them if they didn't do it, which is what they were proposing to do here. So, does anyone have any questions in their own workplace about how this would apply?
So as my question relates to the first case you've stated there, the illness that she was suffering actually occurred on the job.
Yes, that's correct.
So does that also apply to an illness that didn't occur on the job, that someone has brought, someone has acquired
Absolutely.
outside of the job?
Yes.
Yep, so the employer can still request them to take an independent medical assessment?
Safety concern. I'm going to suspend you on full pay and we need to get that checked out before you can keep working. Absolutely.
Okay. The second question I've got is along the same lines, that if the employee is injured on the job and the employer requests them, for example, in our organisation we have a procedure where they get taken for an independent doctor, because many people have doctors that are known for a very long time, and they're essentially stenographers that will write down whatever the individual wishes them to.
Yes.
So we'd like to have an independent one. Is that supported as well?
So is that where an injury's occurred in the workplace?
Yes.
And you're just checking to see, are they fit to keep doing the role, or what's I guess the reason for the assessment?
Because of the over generosity of their family doctor in
If they consent to it, absolutely fine. If someone questioned it, you'd have to be able to tie it back to the health and safety or the inherent requirements issues.
It's more from a workers' compensation perspective.
Well, then that's absolutely health and safety.
Yeah.
And your workers' comp insurer can direct them to do that.
Yes.
Yeah.
But what you can't really do, unfortunately, this is where things get really difficult, is if you think they're not sick at all, but the doctor's just giving a medical certificate, if the doctor is a proper doctor and is genuinely giving the medical certificate, there's not a lot you can do. You then have to go into, well, are they the inherent requirements? We need more information. When are they going to be back to work, to see whether there's some reason you can terminate their employment on the basis they're not fit for the inherent requirements of their job. But it's very difficult, because if you actually think they are fit, you can't terminate them on the basis they can't do their inherent requirements of their job, because you actually think they are fit. But if they have a very docile doctor, you're in between a rock and a hard place.
Yes.
Pick your battles.
So
And that probably ties in perfectly with the next slide, which is about what you can ask for, and this can apply also equally if you're getting consent to talk to an individual's doctor. Often employees won't necessarily provide consent, but if they do, and you should try and get them to sign a form saying that they give consent in case they contest it later. The sorts of things that you want to ask about are obviously, what are their medical conditions, diagnosis, prognosis, questions like how long have they had this medical condition, or how long is it expected that they will be incapacitated and unable to work as a result of the medical condition. Treatment, what treatment have they received, what treatment are they receiving, is there any other treatment that you've suggested that they're not receiving yet. Looking at the inherent requirements, and I'm going to get to that specific component a little bit later because it is quite technical, but trying to get the doctor to focus their mind on what is the position, what do they have to do, and often that can be hard, but you need to provide something that outlines what they do day to day, what you need them to do day to day, so the doctor can try and get their head around that. And then whether there are any adjustments that could be made to the role. You don't necessarily have to implement those adjustments, but often that's the sort of thing that's asked to get that discussion going around, can they actually do the role. So what happens if an employee is found unfit by their doctor or by your independent medical doctor? Basically what you should be considering, firstly, And this is when you're down the track, not when you initially get one medical certificate saying they can't come in for a week. This is the employee that takes excessive sick leave or that's got some long-term injury or sickness. So are there reasonable adjustments that could be implemented? I'll get on to what does not constitute that a little bit later. Are there alternative roles that they could be doing? You know, are there lighter duties that they could do in the meantime? If it's something that's expected to improve, is there some other role that's just become vacant that they could maybe do? You should wait and see, will there actually be an improvement in the foreseeable future? You don't need to wait forever. I've seen situations where someone's sat, you know, for 2 years, not being paid, and they're still technically employed because the employer didn't know what to do with them. You don't need to do that. And then ultimately, do you need to terminate their employment because they can't meet the inherent requirements? Okay, so now on to inherent requirements, which I think is an issue that troubles a lot of people. What does that actually mean? Is it just the position description or is it something else? Basically, what you should have reference to here are some key things. The contract, the function that the employee actually performs, and the organisation, and I guess what it does and what the employer's part in that organisation is. Now, I've taken these sort of brief points here from 2 of the leading cases that are from the High Court. I'm not going to go through them in detail because they're very technical, but I've essentially tried to boil down to what are the key points you need to consider. So what you should be thinking about is, would the position essentially be the same if the inherent requirements, particular things they can't do, or they're not necessarily inherent requirements, if the duties that they can't do were dispensed with, or is it an essential element of the role? So for example, you know, a bus driver needs to have a driver's license and they need to be able to drive a bus. If someone had some sort of eye impairment and they got their license revoked, the key component of being a bus driver is driving that bus. They can't do it anymore. They can't do the inherent requirements of the role. That's obviously a really easy example, and they're usually a lot more technical than that, but they're the sorts of things you have to start considering and boiling the job down to the key components to think about. I'm going to talk a little bit about the Disability Discrimination Act and the Anti-Discrimination Act. So firstly, I thought I'd just point out that there's obviously quite a lot of employees that suffer from disabilities and long-term health conditions, and I think that's why a topic like this is always very popular, because a lot of employers are trying to manage these situations in the workplace and don't necessarily know how to manage them. So under the DDA and the ADA, there's specific requirements to look at reasonable adjustments. Employers are required to go away and consider reasonable adjustments, and they have to turn their mind to it. Often employees might make suggestions to employers about, well, maybe you could try this, maybe I can't do the admin side of my role and someone else could do that for me, or I could dictate it. You know, people will put forward all sorts of different things, including, well, I could maybe just do a different role. You don't have to agree to those things, but they're the sorts of things that you should turn your mind to. What happens if, you know, an adjustment is suggested by a doctor, for example, that you don't think is reasonable, or you think would cause a huge detriment in the workplace to other employees, or maybe would be financially completely unviable? So that's a situation where the relevant section on unjustifiable hardship kicks in. So the employer doesn't have to completely go out of their way to do absolutely everything. If you need to buy some high-tech equipment that's going to cost you $50,000 so that someone can remain employed due to some disability, you're not necessarily required to do that. It's going to depend on the size of your organisation. It might depend on what policies you have in place. A lot of really big Commonwealth employers might have some sort of disability action plan that's actually registered with the Australian Human Rights Commission. Their obligations usually are a little bit higher than everyone else's, but certainly you have to consider things. You have to think about, will this impact other employees? Will it benefit anyone? What exactly will it result in before you make a decision? And then you can turn your mind to, well, do we have to do it or not? Okay, so the last thing that I'm going to look at before I hand over to Helen is just an example of a case where physical inherent requirements were looked at. So this particular case involved a panel beater that obviously had a job that was very physically intensive, required a lot of heavy lifting and moving of objects. In this situation, the employee had a back injury that was aggravated by the work he was doing. He had 4 months off and went and had surgery. And then he came back to work and said, here's my medical certificate, it says I'm fit. Just to let you know, I don't think I'm 100% and I don't know that I can do the full role, but I've got the medical certificate saying I'm okay. So the employer sort of heard alarm bells and thought, okay, well, if you don't think you're okay, we can't have you come back to work and risk some sort of further aggravation, workers' compensation issues, etc. So they tried to offer alternative role, which was a casual role with lighter duties. The employer wasn't happy with that. They wanted to come back and they'd used up all of their leave basically and wanted to get back to work and start earning. Eventually they were terminated as a result of not being able to fulfill the inherent requirements of their role, and they took the case to the Fair Work Commission saying that adverse action had been taken against them for a temporary illness. So in this particular situation, the judge looked at, well, what really were the inherent requirements of the role. Obviously, it's a very physically demanding role. You've had back surgery, some medical information about that. Will you ever be 100% again? Will you ever be able to do this type of role in the longer term? And he couldn't show that. He had the certificate saying that he could do the role, that day, but he couldn't show longer term that he could do it. So ultimately it was held that was an adverse action. He was terminated because he couldn't do the role, not because of a temporary illness. So I think that's just a good example of a physical injury case.